A federal judge in Louisiana refusing to end pandemic-related restrictions on migrants seeking asylum on the southern border today. The judge blocking a plan by President Biden's administration to lift the restrictions, which was intended to expire on Monday. Migrants have been expelled more than 1.9 million times since March 2020 under this Title 42 authority. Arizona and Louisiana led 24 states in challenging this plan to end the restrictions. As U.S. officials anxiously waited on this ruling, many of the migrants crossing the border still oblivious to this massive pending court ruling. But now we have the decision officially, that federal judge refusing to end Title 42. To talk about next steps in this case here, I want to bring in legal analyst Andrew Tchaikovsky. Andrew, thanks for being with us here on this Friday. It feels like things always break on Friday or Monday. This one coming in just ahead of the weekend and that big date of Monday, the judge going ahead and making the decision. Now, what were your first takeaways on this, the timing of all of it?
Well, I think that the judge had to make this ruling ahead of Monday, and it was working all the way to the very end of the day here on Friday to get that ruling done. It's a 40-some-odd page ruling that does establish that the states met their burden to ensure that this injunction was put in place so that the order, Title 42 order, is not lifted. And what that means ultimately, this Title 42 order going back to the Trump administration, making immigration extremely limited, especially kind of in the under the reasoning of COVID-19 restrictions being in place, that the Border Patrol agents didn't have the resources at hand in order to deal with that. Now with COVID-19 restrictions being lifted, even masks on airplanes being lifted, the idea was that the Biden administration was going to go back to the old days and allow immigration and illegal immigration to proceed as it had been. These states all came together to fight that, saying that it would have an overwhelming impact on the states, and the judge agreed.
You brought up a really good point. This has been very confusing, I think, for the average viewer. This started out as a health policy, a public health policy because of COVID-19, not an immigration policy. You know, how big of a distinction is that when it comes to the potential banning of this, the potential lifting of this? Because some argue that the CDC is saying, hey, it's about time to go ahead and lift this. COVID-19, not as big of a concern anymore.
Well, I think you make a great point, and I think that that's the point that ultimately the Biden administration was hanging their hat on, hoping that they could do away with Title 42 because they've done away with other COVID-19 restrictions. Like I said earlier, the mask mandate on airplanes, although that had to be done through the court system as well. But the point ultimately being here that the Biden administration, through their representation in court, was essentially saying that there's kind of a bit of hypocrisy going on here, that the right or the conservatives who really want to keep very strong immigration policies in place are also seemingly the ones who are fighting against national restrictions on COVID-19 bases. So that's kind of the arguable hypocrisy here, but it doesn't really play out because ultimately what's happening is that lifting the Title 42 order should allow the states to have quite a bit of say in what's going on. They should have an opportunity to be heard and to present their case. And that's what the judge is going to allow here. So the influx of immigration, and it's estimated to be as much as 3 times as many immigrants as are coming in right now will come in if this order is lifted. The states were able to demonstrate to the judge that on many different grounds, from an influx in healthcare that they need to provide, education they need to provide, as well as manpower that they need to provide for that influx, that's such a large burden on the states that the judge is granting this injunction. So this trial, essentially, the entire lawsuit, can go forward with more fact-finding and presentation to the court. It's no guarantee that ultimately the court will uphold Title 42 and essentially negate the ability of the Biden administration to undo it, but it will require much greater court time and time in front of the judge with the presentation of a greater amount of evidence.
With this injunction today, though, could there be a potential response from the Biden administration, from the Justice Department, to push back on this and say, no, we want to lift it on Monday?
Absolutely, and I think that you should expect that the DOJ will come back at some point next week, maybe even early next week, with a decision on whether they're going to appeal this to federal appellate court. I believe it's the Fifth Circuit. And the rumors out there is that the Fifth Circuit would not take kindly to the DOJ's efforts to undo this injunction. They've had rulings in the past and indications in the past that they would support such a ruling from the district court as happened today. So ultimately, the prediction is that if an appeal happens, that means that it's an appeal to the Supreme Court. So what the Department of Justice needs to do in terms of its strategizing is determine if they've got a solid case that they want to bring to the Supreme Court now, or if they want to keep in place the current policy, which, as a side note, tends to help the Biden administration. With a huge influx of immigration coming into the country, it will be a manpower disaster and could be really catastrophic on many different fronts. So the Biden administration may actually see this as a sigh of relief, but realistically, they have to make that determination if the Supreme Court is a viable option for them, if this is the right timing of it, or if they want to see this lawsuit out much further down the line before they go through appellate options to undo it, or take potentially legislative action or executive action that could otherwise undo Title 42.
Right, because there's other immigration policies that the Supreme Court has already seen. Last month, they heard arguments about the Remain in Mexico policy, another Trump administration policy there, and they decided to reinstate it and keep it.
That's right. There's also legislation in the Senate right now that is pending a vote. That needs to get out of essentially the lock that they've had on that. The word is that there's potentially even enough Democrats that could help the Republicans push through an act that would ultimately make this lawsuit void as well. So there's all sorts of efforts both parties are putting forward right now as to how to attack this. I think that those who are looking to limit immigration have seen Title 42 as a relatively effective tool to stop immigration at the border itself through the border agents, instead of allowing people into the country for extended periods of time while they fight court battles. So there's many, even on the Democratic side, who see Title 42 or a function of it as being something beneficial to control immigration to a point that really allows for it to be done in a much more orderly fashion without an influx of immigrants coming to the country in an illegal fashion and remaining here for months or years on end while their court cases pend.
Yeah. Interesting to note, it was Arizona and Louisiana that were kind of heading this charge. It was 24 states in total. Why was it ruled on specifically in Louisiana? How does that all shake out?
Well, that's a little bit of the magic of the legal system there. As the plaintiffs, the states essentially got some degree of discretion as to where they were filing the lawsuit, with Louisiana being one of the initiating states that brought this lawsuit. They brought it in Louisiana. There's a little bit of forum hunting that goes on. You're looking for the right courts to take on a case like this. The states that are involved have a direct connection and essentially met the court's burden to establish that they have a relevant connection to the impact that lifting this order would have had. Louisiana, Arizona, both being states that obviously border or are near an access to immigration points. Both of those states had an impact. And so they were obviously very ripe to bring this lawsuit. And the judge spoke of that and found that to be satisfied in the order that was entered today.
Well, we're taking a look at, and I've put it on the screen here quite a few times, but it's miraculous to see still large groups of migrants coming across the border, even with Title 42 still being in place. What do they face when they come to the other side? I mean, what is in their future here? Is there going to be, you think, even more permanent steps, more restrictive steps with Title 42 if it stays in place here? I know these are all kind of hypotheticals, but it's still an issue. We still have so many border crossings every single day.
Well, I think the people who are attempting to enter the country illegally are not doing it with much regard for what the law is. So I don't think that they're spending a lot of time doing a legal analysis of the current status of the law. They're just trying to get here however they can and to get over the fence or over the river in a way that gets them in the country. What Title 42 essentially does is it allows the border agents to summarily deport them. And so what's happening is, depending on where they cross the border, they're taken by a bus or flown by plane to the nearest port of entry, and they're walking back to the country that they came from. And so if they're coming in from Mexico, they're taken to a port of entry with Mexico and the United States and sent on their way. There's a few exceptions there, and it's really in exceptional circumstances. The border agents have the discretion, with the approval of their supervisor, to grant these exceptions in these extraordinary cases. So essentially people who would be subject to a articulable claim of some sort of torture or abuse by being returned to their country. It's also notable that Title 42 generally applies to the countries nearest our southern border. And so there's been a little bit of, I guess, arguments of inequality as to how this Title 42 is being applied to different immigrants throughout the world and different efforts to come into the United States. And that's something that I think is right for any sort of argument against keeping Title 42 in place. But ultimately here, Title 42 has been very effective at allowing border agents and empowering them to return these illegal immigrants to the country from whence they came.
Well, this is just one development in this story here, a story that we've been following for months now. What are you going to be watching as we move forward after this injunction?
Well, I'm very interested to see if the DOJ files an appeal on this, or if they see this through to the end, maybe even using that as a sign that the Biden administration is allowing this to let them continue to be hard on immigrants, even though their political position seems to be inconsistent with that. So I don't know if they use this as a political tool to allow immigration to keep those numbers down. I don't know what the Supreme Court would say about this. They don't seem likely to be particularly favorable to the Biden administration on this. So I think that what we're really looking for here is some sort of advancement of legislation or some sort of additional execution of an executive order that tries to, again, attack this. But as it stands right now, this has been an effective tool that was put in place by the Trump administration to limit illegal immigration. And I think it's going to remain as an effective tool well into the future.
All of this happening as President Biden is not here in the United States, so he's got his work cut out for him when he does return. Legal analyst Andrew Chikoski, thanks for being with us here on the show.
Thank you, Daytona. Have a great day.